My name is Brandon Clark. My wife, she can't be a part of this production. She's a school teacher, like many people who are going to see this video. I myself am a public servant. This video is to bring some clarity, to bring some truth, to shed some light on some very deceitful business practices of a builder that you may have heard of and that you may even consider buying from, Pulte Homes. Pulte Homes acquired Dominion Homes, and they are also the parent company of Centex Homes. We bought our home back in July of 2013. Brand new home, built brand new, everything was new. The driveway was new, and that's where I want you guys to focus on. A brand new driveway, not even 2 or 3 months old. You're living in your new home, and you look outside to see that your driveway is falling apart. Literally, the surface is popping right off, disintegrating. The corner has broke off. I mean, just a progressive disintegration of the driveway. And I'm not exaggerating this. We contact the builder, and at the time it was Dominion Homes. We bring the issue up to them, and the folks that were once smiling and taking their money and telling us that anything that goes wrong within the first year would be fixed is now pointing the finger at us. They said, no, it's your fault. You didn't apply a sealant to your driveway. You put salt on your driveway, and salt just fell from your vehicle. We argued this because we know for a fact we didn't put salt on our driveway. We didn't seal our driveway, so they are right. We didn't seal our driveway. But we started to dig into our warranty documents and things that surrounded the driveway, and started just reading word for word everything, their obligation, our obligation. And would you know it that I found in there that they are supposed to apply a sealant. It's in their warranties. So we escalate the issue, and we still get an abrupt no. No, you're on your own. You should have sealed it. That language was a typo in the contract, in the warranty contract. I've never known of a $1 million company, a large home builder like this, to hide behind the excuse that language in their contracts is a typo. Would they allow the same for us if we didn't obligate our end? You know, perhaps we could say we didn't seal our driveways because we forgot. Even if it was our responsibility, would it be okay then? This is our story about how a company will do anything to avoid liability, to avoid taking responsibility, and to simply avoid what's doing right. Something so easy to keep customer care, to keep people coming back, to keep business growing just by word of mouth. But they have ultimately cut themselves off at the feet with this, and this is my personal mission, to bring awareness to this and to educate future homeowners about the risk you're going to take if you get involved with Pulte Homes, Centex Homes, formerly Dominion Homes. A lot of folks would say, well, it was Dominion Homes, not Pulte Homes. Well, the folks that worked for Dominion Homes were fired in one day and hired immediately by Pulte. They are still in our community building, the same folks. It's not new faces, just different, operating under a different name. So give you a little bit of the story, um, my personality is the type that, I'm going to fight. And I'm going to fight this issue. I'm certainly not going to stand by and take no for an answer in this situation, because we have no liability in this. They should have sealed it. And sealant or not, I've talked to concrete experts that say concrete, if it's poured right, will last a long time without a sealant. So I knew something was wrong with how it was poured and how it was finished. When we kept getting a repeated no, a fellow neighbor suggested that we hang signs on the inside of our windows. I mean, it's on the inside of our home. And first I was like, well, the homeowners association, they're not going to like it. But there's nothing really in our rules that says that you can't hang a sign on your windows on the inside of your home. Quite the opposite. There's a rule that says you're pretty much free to do whatever you want inside your home, to include decorating and remodeling. There are no limitations. And I think that the writer of our rules for our community was very clear, not to implicate themselves and to overstretch their bounds and go into somebody's home. So yes, we put signs in our windows, every one of our windows, that said, do not buy Dominion Homes, and then we quickly updated it with the change of the company in our specific community, do not buy Centex Homes. We wanted to shed light on this, so we had Ask Me Why. And we had a lot of people want to know why. And when they found out, everybody agreed that, a big $1 million company like them, to fix and repair a driveway would be, pennies on the dollar for them. That's not the case. We left the signs up, and we got to meet a management company of our homeowners association, Omni Community Association Managers, and they're based out of Grove City, Ohio, or at least that's their mailing address. David Dye is their president. Linda Lang is our community enforcer, if you will. And then, of course, the Homeowners Association is directly run and governed by builder. So you've got the builder, Dominion Homes, Pulte Homes, Centex Homes. Let's just, for here out, we'll call them Pulte. And then Cloverbrook Farms Homeowners Association, they're both one and the same. They're just operating under two different names. Well, they start to enforce the rules against us and say that the signs are against the rules. We argued that also, and honestly, I think it was a distraction, where they were trying to pull us away from the whole concrete dispute. The signs are in place. We soon turn to arbitration, which is laid out in our deed restrictions. And we go to arbitration over our driveway, and we learned there that the concrete was poured too wet. We got 2 of the delivery tickets for 2 of the loads, and they put excessive amounts of water in each load of concrete, which would contribute to the issues that we're having here. They also didn't cure our concrete, and these are things that I had to learn on my own that are essential to the success of concrete. We won an arbitration. We won a sizable award. And we have won a couple other sizable awards where the builder has agreed to just pay us to go away. They've offered it several times. We'll pay you to go away. But I'm not going away. Quite the opposite. They could offer to buy my house and every other house around me, and I'm not going away. Here's where we start to see the true morals and ethics of this company. The second I filed for arbitration, a few days later, I get notification from my employer that the builder a corporation has filed a complaint on me at my job, a frivolous complaint filled full of lies, trying to get me fired. I mean, this is below the belt. I mean, how can you do that? So I use that to my advantage, and it's actually given me a lot of leverage going forward in all of my endeavors and arguments. The the complaint was filed by a corporate attorney, so I filed a bar complaint on him, and I'm still pushing that. That attorney should have never assisted the builder in filing this complaint on me. You understand, the attorney can't just file a complaint or do something without being told by their client, and in this case it was the builder. So let that set in for a second. You're working, you're disputing something outside of your job, you're doing your normal duties at work, and then you find out that you're now subject of an investigation, based off this frivolous complaint. Luckily, it went nowhere. My employer saw right through it. They knew it was BS, and they even told me, they said, "Mr. Clark, if we thought that you had done something wrong, we would have obviously investigated it. More importantly, if they are stooping to this low of a level to file a complaint on you, you've probably got a pretty good fight against them." And we did. We had a really good fight. Our case was super strong. Well, during this time, the Homeowners Association filed us a $175 fine for the signs. And we argued, you have to give us a hearing before you can before you can put this fine against us. And they argued otherwise. They're like, no, we don't have to give you a hearing. That was a typo that we should have never sent to you, a letter. Well, I get to reading through my rules, and sure enough, it says, you are entitled to a hearing before any fines are assessed, or what they're called lot assessments. So I specifically point this out, and they finally remove the fines, and they give me a hearing. Well, a week before the hearing, I think it was January 20th. Now keep in mind, real quick before we go down this road, we had removed the signs because we had won an arbitration. The signs had served their purpose, we felt. And so the only issue was we just had to resolve this looming $175 fine. But nonetheless, the signs were taken down. So they contacted us on the 20th and by email, and they said, we just want to make sure you're coming to the hearing in a few days. And without hesitation, I confirmed our attendance at this hearing. The very next day, they sent us in the email a lawsuit over the signs that were no longer in place. And in their lawsuit, they wanted declaratory judgment, injunctive relief, and attorney's fees. Our rules provide for attorney's fees if there's any cost of enforcement. And in this situation, the cost to enter this situation into the courts and to hire an attorney was frivolous. I mean, it was without cause. There was no standing violation, alleged violation for that. So the signs are down. They file a lawsuit against us. They want injunctive relief, declaratory judgment, and attorney's fees. Declaratory judgment, they want a judge to interpret the rules and declare them enforceable. Injunctive relief, they want a judge or a court to tell me to take down the signs. Signs are already down, were down. Attorney's fees, that's where they're going to make a little bit of money. Not a whole lot, but it's going to tap into my pocket so that it relieves them of any liability, attorney's fees wise. So, yeah, we confirm our attendance at the hearing. The next day we get sued. Think back. I file for arbitration. They file a complaint against my job. So we go to the hearing, and I make it abundantly clear. Listen, you guys make your lawsuit go away. Where you all filed a complaint against me with my employer, you've failed to give me copies of the records. Let me tell you something. In Kentucky, and by our rules for our homeowners association, they have to give us all the records. There is no added interpretation to that. There's no avenue for you to put your own spin or interpretation on that. It doesn't say with limitations. It doesn't say this. It makes it abundantly clear. All of the records. They won't give me their records. They've breached their fiduciary duty. They have certainly caused us much emotional distress. And the list goes on. And I told them, I said, I'm willing to abandon those claims if you make this lawsuit go away. This is ridiculous. So then they pull me aside quietly. And little did they know that I was recording, wanting to discuss a potential settlement. They still wanted me to pay like $750 of the attorney's fees, waive my right to ever sue the builder again. So if my foundation were to fall apart and it became a structural defect that they wouldn't fix under warranty, I would have no standing to sue them. So I was very concerned with the language in the settlement that they wanted us to settle with. They also wanted us to sign a non-disclosure. They don't want you to know what they're doing. I'm getting ahead of this. I'm getting ahead of them, and I am letting you know what they're doing. We go back and forth in settlement negotiations. We didn't reach any settlement. Their attorney starts contacting me. He's like, you guys need to settle this, as best you can. I'm like, I'm not settling this. I am not settling it and paying a dime for their attorneys. It'd be different if the signs were still up, I would have absolutely no problem forking out, whatever, and we'll settle this. But even then, with the language of waiving my right to ever sue the builder again, I mean, come on. This makes absolutely no sense to want to sue the builder, or to waive my right to sue the builder. So we didn't reach a settlement. We proceed to draft our answer and counterclaim, countersuing them for all the things that I had said before, and then some. I think it was 27 pages, 183 paragraphs, where we answered and we sued back. Would you know it, within a few days of filing my answer and my counterclaim and sending them a copy, they send me a bill for attorney's fees, $2,400, and they're climbing. They keep reminding me that they're climbing. I've made it perfectly clear. We do not care about the attorney's fees because we're not borning the responsibility of paying them. That's where we're at. This lawsuit is pending. We got a very nice settlement over our driveway, and we have certainly bought down our principal in our home. I just want you to ask yourself, though, if we were wrong in the beginning, like if we had no leg to stand on in our argument over the driveway, would we have won? Would we have won any money? No. We wouldn't have. We would have been sent walking. On your way you go. You have no case. It's not the case. We've won twice. Because we were right and they were wrong. And a neutral third party decided otherwise. The second time was settled outside of court that I'm referring to. Their move to come after me, and this is how I feel about it, and this is what other people think, but their move to sue me and my wife, while their lawsuit lacks any substance, This is how I picture the conversation and the process going. I'm Pulte Homes. You know what? He just won a sizable amount of money. It's a very small lawsuit. We'll let him, use some of that money to spend on attorney's fees. Why else would they do it? I file for arbitration. They file a complaint against my job. I demand for a hearing before the association board, who is also the builder. Okay, keep that in mind. They sue me. I countersue, and they send me a bill for $2,400. Everything's reactive. Folks, I hope I haven't bored you, but my story is real, it's true. Dominion Homes, who is now Pulte Centex Homes, is probably the equivalent to doing business with a criminal enterprise. You're going to risk your livelihood at going into business with these folks. They're going to smile, they're going to tell you everything's going to be okay. I'm here to tell you that it's not. I pray that folks do not have the issues that we've had with our home. I pray that you can live and prosper in your new home if you're already a Dominion Pulte Centex Homes owner. But I'm telling you what, guys, this is a horrible, horrible, horrible company. If I can give you any advice, stay away. Go buy you a quality used home, one that somebody's lived in for a couple years, several years. And if you have to do a little bit of fixing up here and there, that's fine. I assure you it's going to be worth saving the heartache that we have went through. And I can honestly tell you that if I had to do this all over again, I wouldn't have. I want you to keep these names in mind and never forget them. Pulte Homes, Centex Homes, Omni Community Association Managers. They're all one. The management company is just like the police department of the HOA. Mike Archer is the president of our homeowners association. He's also an executive with Pulte. Just simmer over that for a while. Think about it. Feel free to comment. I'm sure there'll be some critics. But you know what? We won. We won. Even though we're getting sued now, we won. And we're going to win again. That's our story.